Ni beli duit ni. Kaya, kaya.
Nanti aku bagi. Kau download je.
Assalamualaikum warahmatullahi wabarakatuh. We are from Group 8. We will be presenting on the topic of peer-to-peer network as a possible avenue for copyright infringements. These are our group members. First is me. My name is Sati binti Shamsuddin. My metric number is 055552. Second is Khairunisa binti Muhammad Noor. Her metric number is 054917. And the last one is Muhammad Izul Wajdi bin Zubara Hadi. His metric number is 055263. These are our contents that we will be presenting. First is the introduction. Second, possibility to infringe using peer-to-peer network. Third, the prohibition of peer-to-peer network according to Malaysian law and Australian law. And the last one is the conclusion. So first is the introduction. Copyright is the exclusive right given to the author in order for him to print, publish, perform, film or record literary, artistic or musical material created by him. The infringement of copyright can happen in many ways, and one of them is through peer-to-peer file sharing on networks. Peer-to-peer file sharing networks allow users to share or trade or publish any files or content directly, such as music or video, with one another, as it provides a ready-made sharing infrastructure. Not just the user, provider of a service that shares the infringing copies of copyright material without the permission or consent of the authors, which allow users to engage in copyright infringement, may itself infringe the copyright. Now I will pass to the next presenter.
Assalamualaikum and hi. My name is Khairunisa binti Muhammad Noor and my metric number is 054917. Alright, I will explain regarding the possibility to infringe in peer-to-peer networking. By using peer-to-peer technology to duplicate and distribute photos, music, movies, television shows, or other copyrighted information may be illegal. It is also possible to infringe on someone else's copyright by downloading and then reselling what you already own, such as an MP3 or a movie you did not purchase, or by uploading or plagiarizing other people's work online. However, copyright law covers more than what has been listed just now. There is a possibility that both those who make a copy of the material and those who distribute it could be held liable for violating copyright law and the rights of the copyright holders. For example, when browsing for data or streaming video, peer-to-peer networks do not require centralized coordination by servers. Owners of copyrighted work have three separate categories to consider before filing a case for violation of the copyrighted material. Firstly, people who make and spread file sharing software. No infringement is committed by someone who creates and distributes a peer-to-peer program without encouraging their usage in illegal activities. The second group is made up of all the different internet service providers who give people access to the internet. Copyright law obliges the internet service providers monitor their customer to guarantee that no one was accessing or distributing copies of the works via their network. The third and the last group consists of peer-to-peer users. In order to undertake legal action against these users, it is possible to identify them by looking up their internet protocol address and the dates and times of their previous internet connections in subscriber data maintained by their ISP. Next, I will explain an example of the prosecution against BitTorrent founder Alexander Hump, which a lawsuit had been filed against him by Paramount, 20th Century Fox, Universal City Studios, and Warner Bros. Using the illegal BitTorrent hub, which used peer-to-peer technology, he helped the public download copyrighted films without permission. Nonetheless, it has been clearly decided from this case that BitTorrent's users are the ones who are breaking the terms of such protected movie patents. There are two major types of violating groups, namely primary and secondary. The primary group of infringer is the people who use the copyrighted work without permission from the copyright owner. They have been labelled direct infringers since they directly breach several copyright owners' exclusive right. Secondary infringers are further subdivided into contributory and vicarious infringer based on their role in the infringement. However, even if the infringer was not directly involved, copyright law could hold an individual responsible for the activities of others. When Napster Incorporated was sued by A&M Records for secondary infringement, the court decided whether or not Napster was liable as an infringer. In order to be deemed contributory liable, it must have participated in personal activities that assist or aid the violation. In this case, Napster was found to be a contributory liability for the copyright infringement of its end users, and he was accountable for copyright infringement on behalf of its users. To be concluded, in today's society, the existence of a peer-to-peer network is a troublesome invention. It is difficult or impossible to manage the dissemination of information over the network because of the borderless accessibility of the medium, which makes it harder to control the distribution of such data. That's all for me.
Now, I will be explaining on the prohibition of peer-to-peer network. According to Malaysian law, copyright is recognized in Malaysia and it is governed by the Copyright Act 1987. The works that are entitled to copyright in Malaysia are literary works, musical works, artistic works, films, sound recordings, and broadcasts. In Malaysia, there is no specific provision regarding peer-to-peer provided in the Copyright Act 1987. Section 36, Clause 1 of the Copyright Act 1987 has stated that copyright is infringed by any person who does or causes any other person to do without the license of the owner of the copyright, an act the doing of which is controlled by copyright under this act. Based on this section, it can be said that peer-to-peer network also can be regarded as copyright infringement. Sites that have been used by the Malaysian people which lead to infringement. First is BitTorrent. According to Minister of Communications and Multimedia Gobind Singh Deo, he said that the internet users in Malaysia had downloaded 84 million content files of films and TV shows using peer-to-peer file sharing network BitTorrent in 2018. Based on the report by the local industry, such illegal downloads had cost it RM 1.05 billion in loss of revenue and the government RM 157 million in lost taxes. Also, in the filming and broadcast industry, over 1,900 jobs were lost. Next is the Irdeto site, which is a digital platform security company. In 2016, Malaysia was recorded as the second largest share of content piracy, which at 17%. Based on this, we can see that in Malaysia also, the peer-to-peer network is the largest site that can lead to the infringement. That's all for me. I will pass to the last presenter. Thank you.
Compared to the prohibitions of the peer-to-peer network in Malaysia, peer-to-peer network in Australia occurs to be not per se unlawful. And generally, there is no infringements of copyright in merely using peer-to-peer software. The software usually is made by the owner due to the implied license, and it is always and also would not result in an infringement when one uses the peer-to-peer network to share files containing copyrights if the owner of the copyright material that is being shared has given his consent. And on the other hand, the peer-to-peer network will be prohibited when one uses the peer-to-peer network in which ways they try to share or trade copyright works without the consent of license of the copyright owner. And this kind of peer-to-peer network action will have resulted in an infringement of copyright, and these circumstances usually happens when one makes copyright material available on a server, which is the materials are in the form that can be accessed by others. For example, when there are 3 Australian students were charged by Australian Federal Police in May 2003, where they were found guilty under Section 132 due to the criminal penalties for making hundreds of music files that are available to be downloaded even they are not using the university systems. And the university also can be vicariously liable in some circumstances. As an example, when the university member of staff are acting with the course of their employment, and so the university will be liable for the infringements. Moreover, the university also will be liable for infringement through authorizations liability, and the rights which are recognized in the copyright are the right to do that allows one to authorize someone else to do any one of the exclusive rights. And stated under Section 115 Clause 2, the damages in the Copyright Act are the most common civil remedy, and damages are meant to reimburse the copyright owner for the loss incurred as a result of the defendant's actions breach. And the right number of damages is highly depends on the facts of each case. And also infringement under Section 115 Clause 3 of the Copyright Act, which is the damages will not be given if the defendant can establish that it was unaware and had no reasonable grounds to be suspected that the act constituting infringement was a copyright infringement under those sections. And last but not least, in most countries, including Malaysia, the act of sharing files or content through networks without the permission or consent of the owner may be regarded as illegal, as peer-to-peer file sharing are considered to be under copyright infringements among the countries that have prohibited the acts of peer-to-peer sharing. There are also the countries where the peer-to-peer network is legal, such as Australia. It can be concluded that peer-to-peer file sharing in Malaysia is possible to be a platform for copyright infringements, as it is easy to access by the users. Moreover, it is hard to track them that have infringed the works of the authors in the network. This is because there are a lot of websites that provide illegal contents, which allows other users to commit copyright infringement by downloading the content, and also some of them might have shared it with their peers. However, even though this act is prohibited in Malaysia, but there is no specific provision amount to this, and so this act is prohibited in Malaysia. And this case have been held in this court. However, in Australia, the peer-to-peer network for software is not per se unlawful, and the Australian law prohibited the peer-to-peer network when one use the peer-to-peer network in which ways they try to share or trade copyright works without the consent or license of the copyright owner. Thank you.